Okay, we've got 4 cases to work through on our default calendar. In each of them, as I understand it, but I will learn from the lawyers or the litigants involved, plaintiff either already has a default judgment or is here to get the default judgment, and we're sorting out the damages that ought to flow from that default judgment. I'm just going in order of the calendar. If we need to shift it around because of people's schedules, we can do that. The first position is Taisha Trucking versus Mr. Fofana and his company. Is Mr. Williamson? You're not Mr. Williamson.
I am Mr. Williamson.
You are Mr. Williamson. There was a different lawyer here last time for Taisha Trucking, but I'm glad you're here.
That's probably Mr. Copeland.
Okay.
I have a problem, Judge. My client has moved to Florida, and miscommunication with my office. She did not get the Zoom link, and she did not understand to be here. I didn't learn this until about 7:30 last night. So I would like to add this continued to the next calendar so I can bring her up here.
Why can't she get on the Zoom now?
I couldn't get it to her, Judge.
I can get it to her. If you can get her, we can get it to her. But this has been a calendar that's been published for a while. It's an old case, and this is the day to move it forward. So
can I go outside and call her?
Why don't you try to reach her? It was her job to keep you posted.
I understand.
So why don't you see if you can reach her, and we will shift to position 2. I won't leave till you and I talk some more. All right, let's, and I ask you to keep your microphones muted until you hear your case called. Then you can join us. All right, number 2 on the calendar is Safeguard Public Adjusters versus Community Association Underwriters of America.
Good morning, Your Honor. Steve Yaplin on behalf of the plaintiffs, Safeguard Public Adjusters. Your Honor has already entered a default judgment. We're here to prove damages today. I have 1 witness, and I anticipate my side will take 20 minutes.
Okay. Got a question for you before we dive into it. My staff attorney received a call or an email from Ms. Craig, who was served on behalf of the defendant, and she explained to Ms. Niles, I don't know why I was served. I don't know Community Association Underwriters of America. I don't have anything to do with this case. So I'd like you to help me be comfortable that we really are in a default status because you really did serve Community Association Underwriters.
Yes, Your Honor, I'll be prepared to do that.
Well, why don't you do that?
Okay, Your Honor, I forwarded to your office exhibits on Friday. If you have those exhibits, I can go through them.
Yep, let me pull those up. Hold on 1 second. This is Safeguard Public Adjusters. Okay, so I've got a file called Safeguard Exhibits and Safeguard Exhibits 2.
Yes, Your Honor.
Which one should I open? Which one's going to help me get comfortable that they were served?
I assume Safeguard Exhibits. That was probably the first transmission that was made last Friday.
Okay. Hold on. I'm opening it up here. Okay. Yes, this has the business search for the defendant.
Yes, Your Honor.
Okay.
Okay, Your Honor, I direct your attention to Exhibit 1, which is the Georgia Secretary of State printout. If you look at the top left-hand corner, that printout was made on April 23rd, 2023. The complaint was filed on April 24, 2023. So the day before we filed, we looked and we tried to confirm where the registered agent was. That registered agent, as of that day, 4/23, was Almont Duncan at 574 Griffin Street in Atlanta. If Your Honor will flip to Exhibit 7.
Okay.
Exhibit 7 is the affidavit of service filed by the special agent for service of process. The special agent for service of process, Kevin Stinyard, attempted service on May 8 at 574 Griffin Street, which is the address for Almont Duncan. And that effort was unsuccessful.
Okay, no, I see that. It looks like there were 4 of those, and then for whatever reason, he went to Forest Cove Apartments, which wouldn't ever be a service address these days. And there was this successful attempt where Ms. Craig, I guess, took the paperwork. I'm curious what that address, an apartment on Maury Avenue, how that connects to Almont Douglas or the defendant.
Well, Your Honor, if you refer to Exhibit 2.
Okay, lots of exhibits here. All right, I'm with you.
Okay, as of the next day, April 24, we see that the registered agent has been changed to Contemporary Services Company. And the address for the registered agent is 2 Suncourt, Suite 400, Peachtree Corners.
Yep.
But now, compared to Exhibit 1, where Almont Duncan is listed as the CFO, CEO, and secretary with principal place of business at 574 Griffin Street, Exhibit 2 shows that the principal place of business is now at 2 Caulfield Place, Newton, Pennsylvania.
Yeah, look at that. And the officers are different, and they're all over the country, San Diego and Newton, and very strange.
Yes, Your Honor.
Okay, but I'm still looking for that Maury Drive connection.
Okay.
Oh, look at that. I see. I just jumped ahead of you and went to Exhibit 3. Okay, we're good. That's all I needed to see. You can understand why I was a little confused, but your exhibits, that is in fact the address given in the amendment as of May 2 of 2023. It's Ms. Craig's name and the very address that your process server went. So we are good to roll. Thank you, sir.
Thank you, Your Honor.
All right, so now into the substance of the hearing, what the damages are.
Okay, Your Honor, I would call Clay Melton as my witness.
All right, Mr. Dalton, if you would unmute, I'm going to add you to the spotlight. There you are. Okay, looks like you're operating in a man cave somewhere.
Absolutely.
Excellent.
Mr. Melton, will you raise your right hand? Do you solemnly swear and affirm do you solemnly swear and affirm that the testimony you're about to give to the judge in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please introduce yourself to the judge.
My name is Clay Melvin, registered public adjuster.
And Mr. Melvin, are you currently employed?
I am.
And where are you employed?
I have my own company. I'm the president of Turnkey Public Adjusters.
Okay. And were you employed back in April of 2021?
I was a public adjuster for Safeguard Public Adjusters.
The plaintiff in the above styled action?
Yes.
And describe to the court what your responsibilities and job functions were back in April of 2021.
Well, as a public adjuster, my first priority is to represent property owners in insurance claims, to represent them against the insurance company, as my license allows me to discuss things that contractors and homeowners are not, policy and things such as that. This involves communication with homeowners, communication with insurance companies, writing of estimates, and presenting evidence for, pretty much whatever comes up.
Do you have professional experience in writing estimates?
I do. Several years. I've been a public adjuster since 2017.
And does that expertise relate to property damage losses?
Yes, primarily.
Are you familiar with Brighton Village?
I am.
And describe to the judge what Brighton Village is.
It's a apartment complex.
Where?
In Atlanta, in South Atlanta.
Okay. And approximately how many units are there?
I think there are 24, 25 buildings, something like that.
And that included the pool building?
Yeah, that included pool buildings, the mail area, different, pretty much every structure on the property.
And what were the circumstances surrounding you becoming familiar with Brighton Village?
There was a hailstorm that caused damage, and just like any other thing, I was brought in to examine, give my opinions, and then sign them as a customer.
Okay, so who exactly was a customer?
It was I'm sorry. Oh, I'm sorry. I thought someone was saying something to me. His name was Dominic Burbick. He was the head of the association there, the Renters Association there at the complex.
So the HOA hired Safeguard, you worked with Safeguard to basically assess the value of the damage so that could be pitted against, if you will, what the insurer's saying it's only $1 million. You're brought in through Safeguard to say, you know what, it's actually $1.5 million. Look at this, look at this. You're preparing a report in theory that an insurance company would consider. And if not, there could be some form of resolution between the differing numbers.
Yes, sir. Usually in these instances, I prepare an estimate, the insurance company prepares an estimate, and we negotiate to find a resolution.
Got it.
In this instance, there was no negotiation.
Okay. Okay, Mr. Melvin, I want to refer you to Plaintiff's Exhibit 11.
Let me get that pulled up. Okay.
Do you recognize that document?
I do. That is the estimate that I prepared for the property.
And was that estimate based upon your personal knowledge?
It was. I was on site more than once doing inspections, photographs, note taking, different things. Several, like I said, several instances.
And what was the date of your estimate?
My initial estimate was in May of 21, I believe.
Okay, May 14, 2021.
Right. I hesitate to say that was exactly it, because sometimes when you go in and make adjustments to your estimate, it will update the date on the estimate. Okay. So it was around that period. I just don't want to say it was that exact.
And as of May of 2021, were you a licensed professional adjuster?
I was.
And if you will refer through the estimate, it's about 54 pages. Will you summarize to the judge what that estimate includes and what the ultimate estimate of damages was?
Yes, it is simply a breakdown of each individual building, the components and parts that are on those buildings, and the cost to per the insurance policy, the cost to bring that property back to its previous standing.
And what was the total amount of your estimate?
Give me a second. Let me thumb down to the bottom. again. I want to give you the exact number. I know it, but
It's 1.93 million and change.
yeah. I was going to say 1.9, but wanted to give you an accurate number. But
Yeah,
yes,
no, I see it. It's on page 55. It's a big old number, but it's the sum of there were a lot of buildings that were damaged, roof,
absolutely.
exterior, etc.
Exterior and a little bit of interior as well.
Okay.
Okay, Mr. Melvin, I want to refer you to Exhibit 12.
Mm-hmm. Okay.
Do you recognize that document?
If I can, that's the JS Held estimate, correct?
Yes, sir.
Yeah.
And how do you recognize it?
That is the estimate that, and this is actually not from the insurance company. This is from an engineering company that the insurance company hired. This is their estimate for the work that they say was required to be done.
And what was the total amount of that estimate?
One 135.
1,359,000.
Yes, sir.
Okay. And that's contained on page 56.
Yes, sir.
Now, obviously, that estimate is significantly less than the estimate that you prepared. Did
Correct.
you engage in any efforts to negotiate with either JS Held or the insurer to come to an agreement as to the proper amount of work that needed to be performed in order to remediate and restore the structures at Brighton Village?
I did.
And describe to the judge what your efforts were.
Unfortunately, this was a little bit of a convoluted process. I never had any direct contact with the insurance company. They had a third party kind of be a middleman. So it was a very strange negotiation.
Mr. Melvin,
Yes.
Mr. Melvin, that middleman was not JS Held. So JS Held came up with this number, and you had to deal with like not the insurance company or JS Held, but someone who is neither.
Correct. That is correct.
Does that, based on your answer, it sounds like that was very peculiar to you and is not the norm.
Yes, sir. It was very peculiar. I brought that up to everyone that I spoke with involved in this negotiation. And it didn't make any sense. Was
this third party someone who knew something about general contracting and repair or insurance?
Well, it was interesting. Yes, he was an independent adjuster.
Okay.
Which is, me for an insurance company. The problem was every time I spoke with him, his reaction was, I cannot speak to this. I need to take it and send it in to the insurance company. And then they will get back to me and I will get back to you.
And
that is very strange.
And how did the negotiations or discussions progress?
Not very well. There were long gaps between responses from them. Of course, the third party kept saying, I can only do what they say. I asked several times for the contact information of the person responsible at the insurance company and was told that I could not have that.
Now, there's been substantial damage to the apartment complex where a lot of people live. Was there a sense of urgency that Safeguard had as far as performing the remedial work while you waited for the insurance company?
Yes, and that's typically how it works. Once we get an initial judgment, it's pretty much an understanding between us and insurance companies. We begin the work and then they pay off the rest of it when the work is completed.
And was the work performed?
It was.
And describe the scope of the work.
All of the buildings, the roofs on all of the buildings were replaced. The gutters on all of the buildings were replaced. Damaged windows and window screens were replaced. Just essentially our job is for the entire complex to be brought back to the standard it was prior to the storm that occurred.
And was it
that's
your
what was done.
expectation that during the construction that an agreement would eventually be reached with either the insurance company or JS Held or the third party
Absolutely.
administrator?
Absolutely.
And what happens, Mr. Melvin, in your experience, if it sounds like you're the negotiator, but you were at 1.9, they're at 1.36, and in the end, like, all right, you know what, it's going to be 1.7. That's where they end up. I guess that number is so big, you wouldn't have already accrued enough expenses that you now are owed more than what everyone agrees will be paid. Did that question make sense?
No, I'm sorry. Well, it did until the very end. If you could.
Okay. You mentioned, because Mr. Yacklin asked, there's a sense of urgency. The roofs are damaged, so if it rains again, it's going to be a problem. You get working. So you're working. At the same time, you're haggling. I know you're not the one putting the shingles on, but someone is doing work at the apartment complex. In theory, if this were a typical situation, you and the insurer are going back and forth, and you ultimately settle on a number, likely between the two numbers. Does it ever happen that the people doing the remediation work have already spent more than what the negotiated final number is? And then what do they tear the shingles off saying, well, you know, we did extra work, we're not going to get paid for it? How does that play out?
No. Yes, that is a frequent occurrence. And that is part of what your insurance policy states, honestly. There is something called an RCV policy, which most of us have on our home, which states that the price that the insurance company has to pay for your home is the cost in today's dollars to bring it back to the condition it was in prior to the storm or whatever may have caused the damage. So there is always an agreement between anyone and an insurance company that you're going to get half the money to start the job, and then when the job is completed, you come back and get the rest of the money, and you can negotiate any price increases and things like that at that time.
Okay. Got it. But that's not what happened here. So, Mr. Yacklin, keep going.
Okay. So describe the scope of work. Did the scope of work mirror Exhibit 11, which was your estimate, or did it mirror Exhibit 12, which was the JS Held estimate?
It exhibited mine.
And was it your expectation that even though more work was being done than what JS Held thought should be performed, that eventually you would come to an agreement with the third-party administrator or JS Held?
It was. There are certainly certain things in the JS Held estimate that those in our industry like to call insurance jobs, where they try to undercut the price, and we just have to fight that.
But eventually there was really no fight to be held because there was no engagement.
Exactly. And then the processes that follow were not followed to my knowledge.
So in the end, the scope of work that was performed mirrored the scope of work described in Exhibit 11.
Yes, sir.
At a value of $1,931,680.96.
Yes, sir.
And then not having any resolution, Safeguard then retains my firm to file suit.
Well, first the first step in this process is filing for appraisal. There is an appraisal clause, in insurance policies. However, when we filed for appraisal, it was flatly denied by the insurance company.
And then you retain my firm.
And then we retained you. Yes, sir.
And Your Honor, quite honestly, I fully expected I'd file a suit. The insurance company would have either an adjuster or a lawyer contact me, and we'd negotiate a resolution, and we ended up in a default.
Right.
So
Nothing has been ordinary about, I don't know, I've never heard of Community Association Underwriters of America, but just the almost like a shell game going on with those re-registrations with the Secretary of State would raise eyebrows for someone trying to figure out what's going on there. So, Mr. Yacklin, what's the remedy then? They paid nothing, or they paid what JS Held estimated, and so it's the differential?
Mr. Melvin, will you answer that question?
They, to the best of my knowledge, they paid the JS Held amount. I'm honestly not sure what the final check amount was. I mean, I don't want to speculate to that, since I don't know exactly how much money was received.
Okay. Well, I guess Mr. Yacklin's going to need to fill in the gaps there, so we can get a meaningful and evidentially supported figure.
Okay.
And Your Honor,
Yes, sir.
in the complaint, the breach of contract alleges that the difference in the amount and I know my representations are not testimony. It was my understanding Mr. Melvin would be testifying that the difference was $603,327.37. Clay, is that your recollection?
It is. It is.
Is that, I don't have a calculator in front of me, is that just the arithmetic difference between Mr. Melvin's estimate and JS Held's?
It is, Your Honor.
How is that the correct recovery if Community Association underwriters, we don't know what they paid out? I mean, what if they paid out 1.5 million? I just don't want there to be double recovery.
Right, okay.
Nor, let me finish. Nor do I want there to be double recovery in the sense that, you know, your estimate was 1.93, but it actually only cost 1.8 to do all the work, because then you had a good estimate, but things worked out well and it was less than that.
Right. And I apologize. Let me clarify what I meant there. One of two things, only one of two things happened. We received only what's called the ACV payment, which is that first, which I believe in this instance was $700,000. We definitely received that money. Now, whether we received the second $600,000 to bring it to the 1.3, that I am not 100% sure on whether we received that check. I believe we did, but I am not 100% sure on that, and so I don't want to give you a false answer there.
Okay. And what about what Safeguard ultimately paid to do all the work?
That is my estimate shows that.
Well, your estimate would have been, here's what it might cost if we do it. And you're saying to the penny, your estimate was correct? Unfortunately, with insurance estimates like this, there's very little ever to the penny. We're relying on a software program called Xactimate to fill out the pricing for us. What really it comes down to in this instance is them refusing to pay for certain things or different items.
So
Okay.
at a minimum, the difference, first of all, are you aware of the insurance carrier paying more than the JS Held estimate?
Oh, they absolutely did not.
Okay. So at a minimum, the difference in the two estimates and the work performed versus the money received was $603,327.37.
Correct.
And Your Honor, that would be what we are asking for today.
All right, give me 1 second. Six.
And while we're on here, I've actually sent a text message to our accountant to verify that money for us.
Okay. Yeah, I just did the math of subtracting the JS held estimate from your estimate, and that figure is 572,000 and some change. So this figure that you have cited, Mr. Melvin, must be anchored to actual expenditures rather than estimated expenditures for Safeguard, which means it must have cost a little more than what was estimated, the 1.93. That doesn't mean they're not entitled to collect it. That's not the issue.
Right.
It's just then the math would be what was actually spent, which would have been more like 2 million less the 1.36, and that yields the 600, et cetera, thousand figure that you have.
Yes.
Okay. All right. Mr. Yacklin, anything else?
No, Your Honor. Thank you.
My request to you is that you submit to Ms. Niles a Word document that awards a default judgment to your client in that dollar amount. And I will take it from there just to shape it and then get it entered. And that should close this out.
Thank you, Your Honor. And could you repeat that number, 572,000?
Oh, well, my number was just I'll repeat it, but that's not what Mr. Melvin has testified to is the differential between what I understand was what Safeguard ultimately spent and what
Yes, Your Honor.
Community Association paid. That's a higher figure than what I just quoted, but mine was just based on the estimates. And those are important numbers, but they're theoretical numbers. I'm interested in from the accountants, what did Safeguard spend and what did the Community Association pay? And that gap is where, because of the default judgment, Safeguard ought to collect. And I'm being told under oath that it's that 607,000, whatever that figure is. And that's what should go into your proposed order.
Thank you, Your Honor.
All right. If that's it, Mr. Melvin, thank you for your time. You are free to go.
Thank you, sir.
May I be excused, Your Honor?
Yes, sir.
Thank you, Your Honor. Thank you, Clay.
Yes, sir.
Mr. Williamson, you had success because I see Ms. Hudson has joined us.
Yes, Judge, she's on your Zoom call.
Great. If you want to come up to either one of these, I will. Ms. Hudson, can you turn on your video, please?
Yes, I can. Hello.
Hey, hello.
I put this jacket on so I can be appropriate. Thank you guys so much for your time.
No problem. So you are there. Let's get your lawyer on. There we go. And then I think iPhone 10 is Mr. Fofana. Is that you, Mr. Fofana?
Yes, sir. Yes, Your Honor. Sorry.
All right. Well, let's get started on this one. This is 2022 CV 369347. It is Taisha Trucking versus Mr. Fofana and his corporate entity, Fofana LLC. And Mr. Williamson is here for plaintiff. Mr. Fofana is on for himself only. He cannot represent his LLC. And as I understand the gist of it, Mr. Fofana had entered into a lease to own, or his company did, a Freightliner. He may be sitting in it right now, ironically. $42,000, paid $2,500 a month. He paid a little bit and then no more. So Taisha brought suit saying there was an agreement, you didn't comply, and we need to be made whole. No one responded on the defense side. They fell into default. I have already entered a default judgment, and we are simply working through damages. I should let you know, Mr. Williamson, Mr. Fofana has contacted my office several times seeking a continuance so that he could retain counsel. He was here in person last time we were here and indicated he was going to retain a lawyer. That hasn't happened yet. I explained we weren't continuing things. I'm not quite sure what a lawyer could do for Mr. Fofana or his corporation. They could file a motion seeking to open the default. I'm not sure what the basis would be. They are out of time. And then Mr. Fofana asked for a continuance on the basis that his child was ill and he needed to be with the child. He's on the screen now. It doesn't look like he's with his child, but he's with us. I just wanted to give you that procedural background because I don't know that you were copied on any of those communications.
I was, Judge.
You were, okay.
I don't know about all of them, but some of them.
Okay, I just wanted us all to be on the same wavelength as to, Mr. Fofana has made some efforts, they're belated efforts, but efforts to try to engage in the process. So, and I'll give him a chance to say some things, but I'm going to start with you as plaintiff. If you want to let me know what you want to do, and you've got your witness, Ms. Hudson, on. So let's do what we need to do.
All right, Taisha, if you could raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right. And you are Taisha Hudson, the sole owner of Taisha Trucking LLC?
Yes.
All
Yes,
right.
sir.
And you had executed a 2-page agreement, lease to purchase with Fofana LLC?
Yes, sir.
All right, and what was the lease amount, total amount from the purchase?
$42,000.
And how many payments had he made?
2, the initial when we signed the contract and 1 after that, and that was the last one.
All right, so what is now owing on the agreement?
$37,000.
All right. Have you made any effort to find this vehicle, to take possession of the vehicle?
Through my lawyer, through the police, when I filed the initial police report, they informed me that the title was forged and it had been transferred to someone else. And so that's when I just continued on with my attorney because I wasn't sure what to do after that once the police gave me that information.
As far as you know, the truck has disappeared?
Yes, sir.
All right.
When you say, Ms. Hudson, that the title was forged and transferred, meaning I don't need to get into the forgery part because I don't know how that would be speculation, but it's not registered either to Taisha Trucking or to Fofana LLC. If you are able to look up the VIN, it's registered to some other entity.
Mm-hmm. I believe it's registered to a third party now. I'm not exactly sure.
Okay.
Your Honor, if I may.
You may.
After extensive correspondence with the Georgia Department of Revenue Motor Vehicle Division, they have advised that the truck is actually still registered to Taisha Simone Hudson.
Oh, okay.
But
We just don't know where it is.
It's disappeared.
Okay, got it. But for the official records that exist
Yes.
on the books,
Yes.
Ms. Hudson is still the registered owner.
She is.
Got it. Okay.
And so you are seeking $37,000 in damages plus attorney's fees?
Yes, sir.
And the attorney's fees are according to provisions within the contract?
Yes, sir.
All right. And it's my understanding that we're asking for $3,200 statutory fees under 13.611 and 13.6.1?
Yes, sir.
All right. And the total court costs in this matter are $300.45. Is that correct?
Yes, sir.
All right. Judge, that's our proof. The original agreement was attached to the original complaint.
Right, I'm looking at it now. It's got the 42,000. You paid 2,500 a month. I don't see where it says anything about attorney's fees.
Let me, I think the complaint was under 13-611 and then 13-6.1, Judge.
Okay, It is, both, 13,613 and then 13,111 are both listed there. I maybe misunderstood you. I thought you asked Ms. Hudson if she or her company was entitled to attorney's fees due to the contractual provisions, i.e. there's language in there. I don't think there is language in there. You can look at the contract. It is super short, to the point, but it deals with the money and not anything else. So,
Your Honor, you're correct. There is no provision in the contract for attorney's fees. We're asking for it on the grounds that the truck has disappeared.
and which statutory, I'm not familiar with my truck is gone, so I get attorney's fees.
It's 13,611. It's the unnecessarily litigious and causing us undue burden.
Okay, 13,611. All right. You've got all those figures and you can include those in a proposed order. Let me hear from Mr. Fofana. Mr. Fofana, I muted you for a sec just because there's a little background noise, but if there's anything you want to add, I am happy to hear from you. You're on mute. You need to unmute. Thanks.
Yeah, I said good morning, everyone, and good morning, Your Honor.
I'm going to start with the obvious. Are you in the truck you bought?
Sir, no, Your Honor. I am in actually Kenworth, for a company that I drive for, McBurney LLC. So this is not Carolina, as you can see, Your Honor.
All right, tell me what you want to tell me about the truck that's gone that you paid $5,000 only for.
Yes, Your Honor. I'm gonna try to make it short so everybody can understand the situation that transpired 2 years ago. So I met Taisha Hudson through a good friend of mine that referred me to her. Say, hey, Mr. Fofana has a good trucking business going on. He can help you. So Taisha Hudson had started her trucking company right when COVID hit, and then she actually met quite a few obstacles running her business, and then she was struggling. So she reached out to her. Cameron, which is who her friend and also my friend put us in contact. Say, hey, Mr. Fofana can help you. So I was like, okay, for you, Cameron, I would do that since I've been friends with you for years. So I listened to Taisha. She said she needs that truck to be running, to give her some advice. And I was like, okay, you're struggling. She's like, a driver is now on top of it, and so on. I was like, okay, just leave it up to me. So the Cameron, I'm gonna help you. So what we did, she tried to sell her truck at first. She asked me to find somebody to sell it for her since she was struggling. Clearly, that was not her field to be able to handle all the stress and all the things that came along with it. So I came forward. We tried to sell it right when she wanted to sell fast. We couldn't find any buyer. I was like, okay, since I have a business, let me put it under my business so we can run it. So weekly, you'll get a paycheck and stuff like that. She's like, no, she doesn't want to have nothing to do with it. She just want to get rid of the truck. Okay, no problem. So sell it to me then. But right now, I don't have the cash for it full. I don't have the cash for it to buy it full price. So this is what we're gonna do. We're gonna do a lease to own purchase. She said, okay, that sounds good. I told her how it works and stuff like that. She said, okay, let's draft the contract. I said, okay, no problem, draft it. I don't recall word for word. If I drafted it back then, I think she did. We presented the contract. I think I did. If I'm not mistaken. Yes, I did, Your Honor. So I presented the contract to her.
Excuse me.
On the contract.
Hold on, Ms. Hudson. What is it, Ms. Hudson?
I drafted the contract and he put his
Okay,
letterhead on it.
don't interrupt. If you can't hear him, you can let me know. Otherwise, this is Mr. Fofana's chance to talk.
Yes,
Okay.
that's right. Okay. Yes, as she said, she's right. I drafted it and then I submitted to her for the review, and she adjusted it. So what went down is that Mrs. Taisha Hudson was supposed to hand me the title, and on the contract as you can see, Your Honor, it states that for any person that want to lease the truck, lease to own purchase the truck, they have to either hand the title to whoever is purchasing to make payments in the future to own it. That's what transpired in the contract. She was supposed to hand the title to me for me to register the truck under my business and sign. This is what she did willingly. Nothing was ever forged. She signed it. So she said, this is what's going to happen. I mean, $2,500 monthly. And then as you'll have to make a down payment before I hand you the title. So I make the $2,500 payment right then and then. I got the truck, got a unit. I was busy during COVID, everything was shut down. People were relying on trucks to, move things around, food and everything. So I didn't even get a chance to register that truck. A month went by. I made a second payment on the truck. So it was time for me to register the truck and get it rolling for the truck to generate any funds. Your Honor, I was very shocked and disappointed at the trust I put in Miss Taisha Hudson. Clearly, I didn't know her like that. I met her through my friend. And this is the U.S. DOT and the federal government transportation. Before you put any truck, any unit under your business, you have to make sure that he's compliant, which is when you take the truck to do a full DOT bumper-to-bumper inspection. That has to pass. You got to submit all the other documents for it to be registered under the business. So I was shocked, like I said, to find out that, Your Honor, this truck had caught fire in the past before I bought it. I was told that this truck couldn't pass the registration, the compliance, because he has several issues with it. Came to find out the truck computer system, the ECM, was not functioning at all. That's one. Secondly, Your Honor, I went under the hood, pop up, where the gas is, the clutches and everything, actually lifted up. There was yellow powder of fire extinguisher under it, which means that the ECM that was defaulting caught in fire and the truck was not fully operating. So therefore the truck couldn't pass emissions. So I reached out to Taisha. I was like, I'm very disappointed in you. I put my trust in you because of my friend. Now I'm dealing with this. You made me sign a contract for $42,000 that now I have to honor. Now I want to return the truck. So what's the deal? And then she's like, nope, you already signed the contract. So now it's on you. I was like, what? I said, no remorse, no nothing. You don't do business like that. I put my trust in you to get the truck from you to help you out of a good faith. This is how you're thanking me. She said, sir, you got to make the payment. That's what it is. So you expect me to put a non-operable truck that cannot even pass a DOT inspection. How can I do that? It's not magic. So she's like, it's on you. Like I said, I was at Taisha Hudson. With all due respect, I cannot make any further payment. You want me to honor my monthly payment? I signed the contract. I totally understand that. But on the contract, it says that the truck has to be registered. The truck has to be generating money for me to make any further payment. Fine. I signed the contract. It's on me. Regardless of the fact, I need to make the payment, no matter what happens. I totally understand that. So I rolled with it. I was like, Taisha Hudson, this is what's gonna happen. Let's compromise you. I need to fix that truck because I cannot come out of pocket like that. You need to understand the situation here. You sold me a lemon truck. You need to understand what's really going on here. So she said, nope. I said, okay, no problem. I'm not gonna make any further payment until this truck is fixed, until it's put back on the road. I'm gonna take on the repair cost myself to fix it back. This is what she said. No, this and the third. I said, okay, then come get your truck. And I need the two payments I made from since I got it from you. She said, nope, you got to make the payment. I was like, okay, no problem. So, Your Honor, that's where her and I left off, and she went on. And I was like, okay, no problem. So this is what happened. I'm gonna try to do the best I can to kind of fix it. And your Honor, repair cost came to $15,000. And this wasn't even a sleeper. A sleeper truck is a semi truck that has a bed in the back. This was just a day cab, like a local truck. For me to even invest that much money to even fix the truck in its own, and not that was crazy to me, Your Honor. I was very not happy about the situation. She left me high and dry. To me, this is not the right way to do things. You got to be honest about anything you do as far as like business goes. I mean, it's business. It's not just like a friendship contract. This can backfire on you. So furthermore, Your Honor, a couple of months went by. She went on and hired a detective that called me in his office. I know I didn't do nothing wrong. So I'm not running away from nobody. I went into the detective office in Atlanta, Georgia. He took a deposition, Your Honor, without even telling me that this was going to be a deposition. I'm not
Hey, Mr. Fofana, I'm going to cut you short a little bit. I don't want to get into the criminal side of it. That has nothing to do with Ms. Hudson or me or so. I have two questions for you. One question is, why didn't you get a lawyer involved when this lawsuit was filed?
Again, Your Honor, when this lawsuit was filed, I was not aware of it. I've never been served, Your Honor, until I found out. I had a traffic citation. I went into the Atlanta court to try to to attend my court. And usually I check all my record, to kind of see if nothing happened. So when I find out I had a lawsuit, and then I kept on having multiple calls from some attorneys say, hey, somebody is filing a lawsuit against your business. I said, who's that? So I came to find out that was Taisha Hudson. So at that point on, I cut all the communications with her because I know this was going to be a legal matter until we got here, Your Honor. So this is all I had to say as far as things go on my end. I was scammed, Your Honor, and I have proof pictures of that truck dated on my iPhone, date from when it was purchased, 1 month or 2 months after it was purchased, pictures of the unit itself that had all these malfunctions in it. So that's all I can say to my defense right now. And
so tell me where do you think the truck is now?
The truck, Your Honor, is at a friend of mine's dealership. Is there. I tried to sell it to get as much money I could from that truck since she didn't want it. She didn't want it back. So it's been there. As you can see, as her lawyer just stated, the truck is still registered under her name, which means that no other business is running that truck. And for any other business, any person that want to run that truck has to register the truck. Therefore, the emission, the compliance, you got to take a truck in to get it inspected. The inspection, the US DOT inspection. The truck can.
Let me ask another question. Last question, and I think we can wrap this up. Did you at some point live at 2171 Peachtree Road?
Yes, Your Honor. Mm-hmm.
Okay. All right. No, I'm good. I appreciate you giving me some context in this. That was helpful. I better understand your perspective on it. I'm going to have you, Mr. Williamson, do what I asked you to do, a Word document to Ms. Niles, consistent with the record that was established today, and I will take it from there.
Thank you, Judge.
All right.
I appreciate it.
Ms. Hudson, did you have any questions? I know, Mr. Fofana, hold on. I know you had some disagreements with the version of events that Mr. Fofana shared with me, I wasn't taking evidence on that front today. We're in a posture where today I was simply, in terms of evidence, taking evidence about damages, and you testified to that. Mr. Fofana was giving me some very helpful context, and I appreciate him sharing that. We're in a different space now, though. Was there anything you wanted to add, not about what he had to say, but you understand where we are procedurally?
Yes, thank you, Your Honor.
Okay. All right, Mr. Fofana, do you have any questions for me?
No, Your Honor, that was it.
Okay, drive safely out there. Thank you. You all are free to go.
Thank you so much.
Have the excuse.
Yes, sir.
Thank you.
RH Medical 9 buildings.
Morning, Judge.
Good morning. How are you, sir?
Great, and you?
I'm all right.
Your Honor, my name was listed as the appearing attorney, but I'm going to let my trusted associate, John Christie, handle this one.
All right. His name is the one I got on my crib sheet here, but I'm happy to hear from anyone and everyone. I do have a question before you dive into this about why here rather than somewhere else. There are some related cases rattling around out there. Judge Krause had one that is closed. And then Judge Eric Richardson of our state court, he wears a separate hat, which is a business court judge. And there's litigation going on in business court that seems to implicate some of this. I want to make sure we're not double dipping, or I can't transfer this because this newer case will go to the older case if it really ought to be wrapped up into one. I don't want to create rulings that are inconsistent with proceedings in pre-existing litigation.
No, Your Honor. The other cases, I understand them, are investors, other investors who have sued Mr. Honan and his affiliates, alleging securities fraud and a whole host of like a 200-paragraph complaint. And I think that's the other case. We do have on an affiliate and a completely separate case on a promissory note that is unrelated to this project or these parties. But an affiliate of Orbest does have another lawsuit pending against one of Mr. Honan's entities, but it's not, again, not related to this particular project, investment, or operating agreement or parties.
Okay. All right. So my understanding is that your client invested $3.5 million in connection with an office building on Glenridge Drive, and it didn't go the way your client expected.
Correct, Your Honor. There was an operating agreement, as we alleged in the complaint. The court's already entered, as you know, a default judgment. Mm-hmm. This is here. We're here today on damages.
Correct.
As a breach of the operating agreement. I will say, Your Honor, to clean up the pleadings and the allegations of the complaint, we are prepared to proceed only against 5730 HPE Investor PEPP LLC for breach of the operating agreement, for money judgment, and dropping and dismissing any claims against RH9 HPE Manager LLC, and our claims against 5730 HPE Investor PEPP LLC are limited solely to the failure to return the capital,
and the guaranteed return,
and the additional return, and the statutory attorney's fees.
That is much simpler.
And by the way, I took the liberty of submitting a proposed order and judgment to Ms. Niles this morning before the court. So she has that, and I can make whatever adjustments the court wants and revise it and send it again, but she has it in Word.
Good
for me.
Okay. All right. So for shorthand, why don't we just call it HPE?
Yes.
So HPE would be the defendant against whom you're seeking damages.
Yes, sir.
And you are dismissing as to the other defendant.
Right. I believe But I had this happen before. I think the procedure is you got to drop them and then dismiss the claims. You can't just dismiss the, of course, probably aware of that, just dismiss the complaint. So that's my order that I submitted does reference 9/11/21 to drop them and the claims dismissed.
Okay.
Okay. Your Honor, Mr. Lucas is the manager of RH Medical 9 Buildings LLC, the plaintiff, and I can call him to the stand or proffer his testimony, whichever the court prefer.
Proffer is fine in this setting.
Okay. Your Honor, very briefly, the defendants or the defendant against whom we're proceedings in default, the court has entered a judgment by default against it so that all the well-pled allegations of the complaint are deemed admitted. If called to testify, Mr. Lucas would testify that he's the manager, capital M manager, of RH Medical 9 Buildings LLC. He's a custodian and has familiarity with the business records of that entity. That entity did in fact invest $3.5 million in 5730 HPE. That $3.5 million was to have been redeemed 3 years after the effective date of the operating agreement, which would have been September of 2020. Thereafter, the preferred return of 9% as defined in the operating agreement and in section 5.4 would accrue. That has not been paid on a current basis, and we have submitted an exhibit to the court which sets forth the 9% preferred return, which has not been paid since July of 2021, and that totals $787,500. In addition, the operating agreement provided that the redemption would be for the $3.5 million plus the accrued additional, preferred return, the additional preferred return plus the additional return, which is defined as $700,000, 80% of which is allocable to the plaintiff. So that would be $560,000. So Mr. Lucas would testify that the initial capital of $3.5 million has not been paid, that the arrears in the preferred return of 9% as of today is $787,500, and that there's an additional $560,000, 80% of $700,000, which is the additional return, for a total amount of $4,847,500. Then pursuant to paragraph, I'm here in a minute, it's 14 or 15. Paragraph 15.11 of the operating agreement, which is attached to the complaint and in the record in this case, that we are entitled to statutory attorney's fees, and we're asking the court to award statutory attorney's fees of 10% of the amount due, or $487,750. And the proposed judgment is for that I've submitted to the court is for $4,847,500 plus the statutory attorney's fees of $484,750 plus costs and post-judgment interest at the judgment statutory rate.
I'm assuming there is some case that says that ridiculous attorney's fees amount I have to grant. And that's not to suggest you haven't worked hard on this case, but I suspect you haven't billed $500,000 in prosecuting a default judgment case.
Well, we've only got 9 lawyers in the case. I'm not in the firm. I'm not sure more than 9, but we've only got 20 lawyers in the case. We work full time. I'm not sure we could get to that number. However, that's why the statute was enacted. I think 13-111 was revised to allow parties to complain or ask for a review of attorney's fees. That was not made in this case. So yes, unfortunately, that's what the Georgia legislature said.
Okay. I don't begrudge you at all. It just, I am always leery. The optics are poor for the legal profession, that this is the result of a default judgment. There's a $500,000 in attorney's fees, and there wasn't necessarily a $500,000 in attorney effort.
Well, I think what needs to be made clear to the public is that money goes to the creditor. It does not go to the lawyers. And in fact, when it's invoked, it bears interest at the contract rate. So, there's a lot, bank has a rather influential lobby in the legislature.
Oh, well, it needs to be made clear to me, and then I can help make it clear to the public. So that's not something that your client has to give to you. They will pay you what they think they owe you, and the rest they get to sit on.
Yes, that's what the law says. Yes, sir.
Oh,
I've litigated that in the bankruptcy court many times.
Okay.
An argument and lost each time.
Interesting. Okay. Yeah. So I can see why there would be, I guess it's sort of just a litigation penalty. But if it's in the contract, I mean, more importantly, it's in the contract. So people go in with eyes wide open, and these were sophisticated parties on both sides.
In this case, that we're judge in Alabama is 20%.
Oof.
And don't forget, this is, 13,111, it's 15% of the first 500, 10%. You can get up to 15%. Could be worse. So there's the good news. It could be worse.
Well, and it's not a bad news situation. It's not like they're clean hands on the other side here. It's just already some big numbers, and then these get stratospheric. But I didn't appreciate that nuance, and it's not a nuance to you. That's not going into your firm's pocket. It's going to your client, and I'm sure they will compensate you and your colleagues handsomely, but it will be a fraction of that amount.
Indeed.
Okay. Well, Mr. Lucas, I'm sorry you didn't have to say anything. I'm sure it would have been good, but Mr. Christie, as usual, has summarized it. The numbers are higher than what were originally sketched out, but that's only because time has passed, interest accrues. The additional return is fixed. It's that 80% of 700,000.
Right.
It's the preferred returns where that number is going to keep growing. But
$78,500 a quarter.
whew, all right. Do we think HPE is even, I mean, is this a judgment that can be collected, or it's just going to be pretty paper?
Well, we're going to find out.
We're going to find out.
I'll let you know next time I see you.
Yeah, well, good. I'll try. I won't remember all the name. I'll remember RH. That's like RH9, but it's a mouthful on the other side. I appreciate your time. Ms. Niles has already sent me the Word document, and so I will take it from there.
Judge, I want to introduce this is my daughter, Jamie Christie. She's a lawyer associate with us. She clerked for Judge Batten in the district court. And then
well, good for you. One of my favorite judges. Does that mean you were down in Newton or wherever?
Sometimes, yes, in Newton.
Newton.
Mainly here in Atlanta,
Okay. How long were you with Judge Batten?
just a year.
Okay, great. And then you joined the firm?
Mhm.
All right. Well, welcome aboard.
Thank you.
Good to
Thank you,
meet
Judge.
you. All right. You guys take care.
Bye-bye.
Last but not least, Ms. Beaton. You all can come up. I need you near a microphone. Oh, and we have someone else here.
Judge Vince Lally on behalf of Creative Multicare.
Huh. All right. Let me get a piece of paper here. And Ms. Beaton, you tell me what works. You can certainly remain seated. You pick, it'd be best if you took the middle seat. And then you can have around you. I know you asked Ms. Niles if folks could speak on your behalf, and that's fine-ish. I'm gonna need to explain a little bit about how that'll work, but why don't you take a seat? And
Use the wheelchair. It's more comfortable.
sure, oh, please, yeah. We can roll those out of the way and you sit in the wheelchair.
Y'all have chairs.
Sorry about that swinging door. In some courtrooms, they've removed it. Yeah, we're not that sophisticated in 8D, but I need to get something like that. All right, this is the matter of Marilyn Denise Beaton versus Creative Multicare LLC. This is a hearing on, it's a default hearing overall, because I haven't entered a default judgment order yet. Ms. Beaton is proceeding pro se, but Creative Multicare was served. I explored that pretty thoroughly before we set this down. And until about 3 minutes ago, I had heard nothing from Creative Multicare. But why don't you give me your name again so I can write it down?
Vince Lally.
All right. And you've been retained by Creative Multicare?
Yes, Your Honor. We got the file in on Tuesday. The Creative Multicare learned about the default on Tuesday, contacted their insurer, and they assigned us.
Okay. Let me pull, everything is a little slow because of it's now public, the hack, the cyber attack. So I have to pull things up through it's not old, just an alternate system. And And I want to address one thing with you, and then you can share with me what you think your client's able to do, if anything, today. And I certainly want to hear from Ms. Beaton or someone who's going to be speaking on her behalf. But let me pull up.
And Judge, on the system, the non-public hack, we filed a entry of appearance and a notice of our intent to file a motion to open default.
That I can, if it was filed recently, I'll be able to pull that up. I was looking for the certificate of service, but
I believe we filed it on Tuesday.
No, not your certificate of service. The evidence that your client was served a long time ago, and here you are now.
Yes.
So, yep, whatever you filed hasn't hit the docket yet. That doesn't mean you didn't file it. That means that the whole e-filing thing is slow because of the cyber situation. Let me look up what I need to look up here. So Creative Multicare was served on September 20th of last year. A Teresa Dean was handed all the paperwork. Tell me what you mean they learned about the hearing just a few days ago.
Yes, Your
And
Honor.
how would that have happened?
So Creative Multicare was served on September 20th. The representative that normally handles handling suit papers for Creative Multicare, he wasn't in the office. They did serve a Teresa Dean. And then when he returned to the office, he received the papers, gave them to his assistant. She sent them over to their insurance agent. The agent at the time was in a medical facility with his wife while she was undergoing some chemo treatment. The communication fell through, and he never, the agent that is, never forwarded the papers over to the carrier to assign them counsel. So the carrier never learned about the suit. And
So what your argument will be, and it may already be in things I can't see yet, that it was negligence or inadvertence of the insurance agent and not your client.
Your Honor, yes, we're going to argue that it was excusable neglect on our client's part.
Right.
And if it wasn't excusable neglect, we would argue that it's at least a proper case based on the client's actions since learning of the default. They immediately contacted the carrier assigned us, and we've begun working on getting some affidavits and getting the motion drafted.
Okay.
And Judge, if there's not a default judgment in yet, we weren't even sure this morning whether or not there had been a default judgment entered. With no default judgment entered, we would also argue in our motion that there's not going to be any prejudice done to having the case tried on its merits.
Okay. Got it.
Thank you.
You're welcome. Thank you for being here. Am I pronouncing your name correctly when I say Beaton?
Yes.
Okay, Ms. Beaton. I'm Judge McBurney. It's nice to meet you. I've read some about you through the things you filed. We're in now a more complicated situation than I thought we'd be in. I thought that what was going to happen today is that I would hear from you or folks who are close to you about what happened. And I have a rough idea of what happened through things you've already provided, where you stepped on some nails and were hurt. We're already recovering from something else and have been suffering since then. Creative Multicare is now in the mix. Here's a lawyer representing them, and I need to make sure they have an opportunity to get in front of me, their argument, not why you're not entitled to anything at all. It's way back from that. It's an argument about why I ought to hear anything from them at all. A default judgment, which is what I thought we were going to do today, is a fairly extraordinary remedy, because I say you win without ever hearing from the other side. And that's not the norm. Normally, it's a back and forth, back and forth. You had to sit through that trucking situation. I wanted to listen to Mr. Fofana so he could feel like I was listening, but he had already missed. He actually came to court once, like, I don't think I'm not going to worry about this. So he had a chance to engage, much like your process server served Multicare. The young lady in Florida had someone serve Mr. Fofana, and he decided he just didn't want to engage in the process. So I had already entered a default judgment saying, because you are choosing not to get involved, the other side is going to get what it's asking for. You can't delay things by not getting involved. If you serve someone and say, be on notice, I'm going to sue you for something, the other side needs to respond. And Creative Multicare was on notice. We've heard Mr. Lally explain how they were. He's got some reasons why maybe they still ought to be heard. I haven't entered that default judgment yet in your case. I had already done so for Mr. Fofana. So I was happy to listen to him up to a point. But that wasn't anything that would change anything, because I had already signed an order that said the trucking company wins. You took their truck, you didn't pay for it. And even though he had a story about fire extinguisher dust here and it wasn't working, that all may have been true. He just forfeited the opportunity for me to weigh that. Creative Multicare has started knocking on the door now before I entered that default judgment order. And I'm required legally to at least read their pleadings and decide too little, too late. That's one option. Or, look at that. Their affidavit showing that right after Ms. Dean got your lawsuit, she handed it to the right person who handed it to the right person. And then someone outside Creative Multicare dropped the ball. And if I find that's what happened, I don't know that I will, but I could decide Creative Multicare has a chance to answer, so that we're actually having a conversation in both directions, which is how it ought to be. That's the normal approach. But like I said, you shouldn't have to wait forever for the other side to speak up. And if I conclude that really Creative Multicare should have been calling me, wait a minute, you guys haven't done anything. It's been a month. And whatever happened to that lawsuit? What lawsuit? And maybe before a few days ago, they should have been scrambling. But I need to see, and you need to see, what they have to say. You'll actually get a chance to respond if you want to. You don't have to respond, but what Creative Multicare files in an effort to try to open the door back up, you'll have a chance to submit something if that's what you want to do. I didn't expect that this would happen. I was very surprised to see Mr. Lally here, but in the nick of time, he has appeared. So at least we have to have that conversation about, do we open it up so that it's a two-way discussion, or do I say too little, too late? And then we'll do, again, what we were going to do today, which was an opportunity for you directly or through folks who are here with you to help me understand what your damages are. Because it's not just because you write the number down on a piece of paper. I need to understand, what did you spend? What's been the emotional suffering? All those things that would go into a judgment in your favor. So you should be disappointed because this isn't what either you or I thought would happen today. But it's my job to make sure that I give everyone at least a listening to, sort of like Mr. Fofana earlier. The difference is this is one that is just in time, and I have to give it a formal listening to. In other words, let these documents be filed and even see if you want to say anything in response. That's in writing. You're not going to have to come back into court. And then we'll see what flows from that. And so you know, in case you have questions, there are two possible outcomes. One is I say, this is too late. I don't find that Mr. Lally used the correct phrase, excusable neglect. I think that's not what you said?
Yes, Judge.
It is. That's one of the categories for opening a default is yes, someone dropped the ball, but we can all understand why, and we don't fault them for it, as opposed to, I'm just not, this is an annoyance, and Ms. Beaton can't be taken seriously, and I'm just going to ignore it. That's not an acceptable reason, but if it plays out the way Mr. Lally said, maybe it is. So that would be, I reopen for them, and they file an answer. They have to pay a fee to the court, not to me, but into the system. And then they would file an answer, and then we would need to start having this be a back and forth. And it may well be that Mr. Lally would want to talk to you or your family representative, but you don't have a lawyer, so he'd be reaching out to you directly to say, maybe we should settle this case. And you might say, nope, I want a jury or a judge to hear the case. You might say, that's great. I just need someone to acknowledge they did wrong and they owe me some money. And you guys would work through what that money is. That's how most cases resolve. They don't usually result in a trial, but I'm here for trials. And so if that's what we need to do, that's what we'll do. Option two, I guess that was option two. Option one is too little, too late. And we just have to come back here and talk about your damages. The other option is they do get to file their answer. That's what the document's called. They answer your complaint, and then we figure out what to do from there. So I just talked for a long time. Do you have questions about what I described?
When I say, when you said too little, too late, I don't